In my opinion, character cannot be used to determine or predict the accused's misbehavior conduct, and that therefore the bad character evidence has no any probative value in any criminal cases. It is therefore irrelevant to notify the court on the past misbehavior conduct of the accused. Supporting it with the case of PP versus Hellsby, Lord Halsham stated that when there is no any particular elements in support to the offence done, except for the bad character evidence or any such elements in support of the offence, then such evidence is said to be nil. Next case, Ramanathan Chelya versus PP. One is of the view that a man in handcuffed and standing on the deck is said to be guilty when he is proven, and when it comes to nowadays case, it is whether he is proven guilty or innocent, it depends on the evidence tendered to the court. The court held in this case that Section 54 of the Evidence Act 1950 is inadmissible to the court as it is not pursuant and it will cause prejudicial elements to the accused when the court applies bad character evidence as tendered by the public prosecutors in this case. The court held that whether the accused is proven guilty or innocent, it depends on the outcome of the trial. In the case of Sankar Esparan versus PP, this case proven that the first appellant together with PW17 and his friends causes nuisance to the occupants of the apartment, which clearly evidence shows that they caused a bad character evidence under Section 54 of the Evidence Act 1950, which is definitely prejudicial and inadmissible to the court. The trial judge is duly bound to stop the defense from adducing it. Since it is inadmissible, it always remains inadmissible whether objective is raised or not. Moving on to the recommendation part, personally I believe that bad character evidence is not inadmissible in the court. However, there are elements to be admissible as there are exceptional elements to be submitted or tendered by the prosecutions in the court. However, a person should be judged strenuously by reference to the awesome spectra of his past life, and it should not be done ever in the court. It has elements to be offended, which it has to do with the alleged facts of the defense with which the defendant is charged, or is evidence of misconduct which is in connection with the investigation of the prosecution of that offense. I personally believe that the principle of Section 54 of the Evidence Act 1950 should be applied fairly and which does not prejudice to any one of the parties. The justice occurred or delivered from the Section 54 of the Evidence Act 1950 should be equal to the both parties, either to the accused or to the opponent parties. There should be no any discrimination offered, as there are a stronger point, namely the prosecutor to tend or submit any such evidence which could make or include the bad character evidence as well in order to prove that the accused is proven guilty. It should be taken into considerations that bad character evidence should be excluded as past misconduct behavior of the accused is nothing relevant or nothing could be done to the court, as even that relevant materials were implied to the court upon the accused. Therefore, to conclude, I would say that Section 54 of the Evidence Act 1950 should be applied fairly and should be avoided in terms of the bad character evidence or include in any such evidence in the court in order to avoid injustice or unfairness upon the accused in any criminal trial.